Hey everybody, it's Todd Henry with Inslee Best Doezie Ryder, law firm in Bellevue, and we're going to talk today about some COVID-related construction impacts. I'm calling this learning as we go because, as many of you have experienced in your businesses, the field of what we've experienced since this all started now a year ago has changed dramatically. So as an introduction, and before we begin, there's three things that we're going to be dealing with today. The first is I'm going to be providing you with some information. I'm going to be providing you, secondly, with some interpretation of that information. And third, I might provide some of my own opinions. So I want to make sure that we understand that even though I'm a lawyer, I'm not providing anybody with legal advice today. And anything you do related to contract claims, contract negotiation, or dealing with the legal issues that result on your projects from the coronavirus pandemic ought to be run by your lawyer, and you should give a call to her or him about these things. Always confirm your actions with those people. So you guys all remember it was just a year ago, February 25th of 2020, when Governor Inslee issued the stay home and stay safe order that essentially closed all construction with some very small exceptions, and began to have all of us deal with this incredible phenomenon called essentiality. Who's essential and who's not? What businesses were essential and what were not. Initially, when the governor issued that order, construction wasn't deemed essential, except for very narrow issues, some public works projects, and then with regard to making project sites safe. In other words, protecting the public from things that might happen during the time a project was idle. And protecting the property from losses. And so some people were able to continue working, but solely in a way to try and get themselves in a position where the site could be safely left while we dealt with the rest of the order. So after that, there were huge confusions about what happened to the stay safe and stay home order, and interpretations galore about what construction was essential and what was not. I know I had my own issues where I was at home. Our office was shut down like a lot of them were. And walking through my neighborhood in the early spring of 2020, I saw people that were refinishing floors and putting in furnaces. And I wondered what they were doing, because those were clearly not essential tasks under the governor's then order. And a lot of that happened around where people interpreted things to say, well, you know, I'm looking at this order and I think if I close my eyes and I squint into the sun and I hold it up to a mirror, I'm essential, so I'm going back to work. That really wasn't the case. And so one of the things that happened between the time in February 25th and the next month is a lot of lobbying went on in Olympia with agencies, and also with the governor's office from industry groups to try and reopen construction. And during that time, a lot of contractors came up with plans for what they would be able to do, having received the guidelines from the state and from the CDC about what was allowable, what was safe, and what was recommended, to come up with the plan, like the plan you see in the lower right of this slide, which is a plan that one of my clients received during the time that a project's work was suspended, and which outlined in huge detail what safety measures were going to be taken and enforced on the project when it reopened. So by March, we were beginning to see those kinds of plans. And lots of new site protocols, just like that COVID-19 safe job site checklist that's in the middle of the bottom of the slide, were being issued by general contractors and by project owners and developers that had, from just the initial review of them, were going to have enormous impact on job site issues. They were going to change the conditions under which projects were going to be able to continue, including notably with regard to issues of access, with regard to what activity was going to be allowed at all, with regard to how many people could be in any one place, what tasks could be done with people in close proximity to each other, what PPE was going to be required that had not previously been required. And all of those issues began to foment and caused everybody a lot of concern about what was going to happen when the issue of contractors' essentiality, as I called it earlier, came to the forefront, and that work was going to be allowed to continue. So when all of this happened, many of we lawyers and our clients ran to their agreements to see what contracts said about not being able to continue the work and what compensation might have been available. So as you know, there are a number of standard agreements. The preeminent set of standardized construction agreements are the Architects Institute of America, the AIA documents. And the force majeure clause, and we've got a slide about force majeure later, but the specific force majeure clause in the A201 2017 edition, general conditions, there is none specifically. There is no standard force majeure clause that talks about the kind of typical force majeure issues that we see, labor, lockouts, those kinds of things. However, 8.3.1 of the 201 general conditions does have a list. It is a perhaps force majeure light clause that talks about other causes beyond the contractor's control as the basis on which, under Section 8.3, a contractor might seek an extension of time for a delay that's been caused. And you can see by the clause that I have excerpted here, labor disputes, delays in deliveries, okay, those unavoidable casualties, some of those things are typical force majeure issues, adverse weather conditions, unusual weather conditions, and then that next one, or other causes beyond the contractor's control. That catch-all has been interpreted in many cases since February 2020 to be the catch-all that encompasses the pandemic. The problem with this clause and with clauses that we see like it is that this clause and the surrounding clauses in the 201 general conditions provide for extensions of time only and no compensation. And regardless, as the last bullet point on this slide says, the ability to recover under 8.3.1 and to even have an argument about not only time but money requires the kind of standard compliance with the notice and claims provisions of contracts that in Washington State are the law. Many of you are well aware of the Mike M. Johnson decision from 2003, a Washington State Supreme Court decision, in which our Supreme Court has essentially said if there are notice and claims provisions, they have to be strictly complied with. They can't be substantially complied with, and they can't be sort of complied with. They have to be strictly complied with. And that line of cases has become a great controversy. Public owners love them, and developers love them. But contractors don't like them because they visit a waiver of the possibility of recovery of time and money if the notice and claim provisions haven't been exactly followed. So let's look at another one of the prevalent standard form contracts, and a little different one here. This is the consensus documents. And for those of you that are unfamiliar with the consensus documents, they were developed in the late first decade of this century by a consortium of industry groups and professionals, including the Associated Builders and Contractors, who tried to come together and come up with a set of documents that they felt were more fair both to the owner and to the contractors. And consequently, the name consensus documents. Tried to come up with something. As you know, the AIA documents are drafted by the architects. So those are both favorable to the owner and the architect. They are well understood, and there's a lot of legal authority interpreting the AIA documents. But many groups thought that they could be improved on, and consequently, a lot of those groups came together to form the consensus documents group and come up with their own set of standardized documents, which they published some years ago now, and which they continue to refine. The consensus didn't work exactly because not all the members of the consortium agreed with the final documents that the consensus docs published. But in my practice, I have seen them a little bit more prevalently in recent years. And I have a number of cases in which the consensus documents were either the exact document that was the contract or were the basis of the agreement that my clients were tied to. So it's important to understand those. So a consensus document, this is a snippet from document number 200, the standard agreement between owner and contractor. So this is from a prime contract, not a subcontract, but a prime contract, likely to have been flowed down through a subcontract by an incorporation by reference, so that the force majeure clause that appears in this one, again, 6.3.1, talks about the fact that the constructor, in this case, is entitled to an equitable extension of the contract time. And there are listed a number of causes, and if you go down to causes J, K, and L, it specifically includes epidemics. It also includes adverse governmental actions, which may encompass the orders under which we were all under to stop working and to stay home. And again, L, unavoidable accidents or circumstances, which harkens back to the language we saw in the AIA 201 general conditions. Now, additionally, 6.3.2 of this document indicates that if the constructor incurs additional costs as a result of a delay that is caused only by items A through D in the preceding paragraph, the constructor shall be entitled to an equitable adjustment of the contract price. So J, K, and L are excluded from that provision, and therefore under the consensus documents, presumably, there would be no damages for a delay caused by epidemics, adverse governmental actions, or unavoidable accidents or circumstances. Obviously, the intent of the drafters there is to make sure that it's a no harm, no foul provision in which something that the owner could not have foreseen and for which the owner has no control would not result in the owner having to pay despite the fact. Now, the problem is I'm not exactly sure how these provisions in the consensus doc harmonize with RCW 4.24360, which is commonly known as Washington's no damages for delay provision, in which the Washington legislature declared that any construction contract that would exclude a contractor's right to an equitable adjustment in the contract price for a delay that was the responsibility of the other party is void as a matter of law. So I'm not exactly sure how this works other than if J, K, and L in 6.3.1 are interpreted as not having been the owner's responsibility. Again, any claim arising under 6.3.1 or 6.3.2 is going to require strict compliance with the notice and claims provisions of the consensus documents, which are not terribly different than those found in the standard AIA documents. So what did we see when we all went back to work? What did we see? Well, we saw a lot of things happen, and it mobilized lots of industry groups, and especially notably the four whose logos are on this slide. SMACNA, which is the Sheet Metal Air Conditioning National Contractors Association, NECA, the National Electrical Contractors Association, MCAA, the Mechanical Contractors Association of America, and ASCE, the American Society of Civil Engineers, all dove into this issue in significant depth. Both NECA and MCAA have published lengthy analyses and guidance for their membership on the issues of inefficiency, delay, and those kinds of issues. And piggybacking on those, these groups then began to explore what kinds of problems we were seeing and what kinds of solutions they would recommend to their membership with regard to the restart of work under the changed conditions in the post-pandemic world. In other words, when we all went back to work and became essential, what changed on our job sites and how did we deal with that? Well, in the bullet points, I'm talking about things like work stoppages or suspensions, where the project had been partially or completely shut down for a certain period of time. And then the work restrictions that were imposed upon restarted projects, including the enhanced level of PPP and the other social distancing, cleaning, screening issues that we all began to see on our projects. Each of these sources began to provide some, and early on in the pandemic, began to provide some guidance to their members about how to deal with these issues. So here's the kinds of things that we saw. And as you'll see throughout this presentation, as I've already mentioned a number of times, the first one is the most important. Without notice, there's no ability to recover. So we always have to reserve our rights. I think a little later on in this presentation, I talk about the fact that notice is just business. It doesn't mean that we're trying to get one over on the party with whom we have a contract or anything else. It's simply a requirement, and we have to look at it in a way in which we're simply reserving our rights. We can always later say we don't have a claim, but if we don't provide the notice, we definitely don't have a claim, and that becomes our problem. So lots of contracts, including notably the AIA documents, contain specific language about suspension, and it sets out the compensation to which a contractor is entitled during a period of suspension. That compensation has to be proven, the rights to it have to be reserved, but the contract sets out compensation for a period of suspension. Under most of the standard clauses, as we've seen the two examples, the owner is generally required to compensate for a period of suspension. And that is an important term. Suspension is a defined term in those agreements, and it's the suspension that triggers the ability to recover money. So now a government imposed moratorium, I called it a suspension here, and that probably was the wrong term to use, moratorium, like the stay home and stay safe order, may be an issue of force majeure. And that may hearken you back to the 6.3.1 and 6.3.2 like clauses in which the owner essentially has, at the contract period, absolved itself of responsibility for certain actions and for certain issues that were not only beyond the contractor's control, but were also beyond the owner's control. And that's where we find ourselves in an argument with owners or with general contractors, depending on who we are in the chain of privity, with regard to whether or not we're going to be able to be compensated for the period in which the work was not allowed to proceed. So back in March 25th, so a month after the stay home safe order, the governor said all construction activity were essential, and we imposed upon all of our sites social distancing, appropriate health and worker protection measures, and all those kinds of things before we could go back to work. So let's look at the resulting impact, what I call the changed conditions for the restart. One of the things we found was additional requirements for masking, for sanitation, and for other PPE, requirements for distancing, requirements for pre-work health checks. There were many places in which people had to line up in the morning and have their temperature taken before they were allowed onto the site. Changes in some schedule durations. In other words, when the work restarted, the schedule got juggled some in order to help compensate for the period of time in which no progress was able to be made. There were huge, huge impacts to site access issues. And I talk about man lift use. What I'm talking about is the number of people that could be in the man lift at one time. I'm also talking about the number of people that could be in any space on the project at one point in time. And the census limit, the number of people that were allowed on a project period, and in many cases, those were significantly curtailed. I also heard tell of projects in which teams, especially projects, large projects, downtown high-rises, for example, in which what would have normally been simultaneous rough-ins, for example, being done by the mechanical, electrical, and plumbing trades, were staggered in such a way that a team from one trade was only allowed on the floor at one time. Well, that significantly, obviously, changed the project with regard to duration, with regard to the ability of the work to be progressed efficiently. And that's what led to the kinds of analyses that those industry groups were providing to their membership with regard to how the change conditions were going to impact the work looking forward as we tried to restart the work within the pandemic period based on what we had to deal with regard to the impositions of those requirements by the government. So all of these issues, as soon as they were able to be understood to exist, required that immediate compliance with written notice, and then the follow-up quantification requirements required by individual contracts. I saw many clients who came to me with their draft notice letters and asked me to look over and see if they'd forgotten anything. And many people that came to me with curiosity about how the contract documents would be interpreted. Some of that is yet to be seen, but there was no reason for everybody that came to me not to do the right thing in reserving their rights, in trying to come up with the ability to make a claim for the way that the work had changed. In so many cases, the work was much, much less efficient than had been anticipated in the pre-pandemic period. For example, if you had thought that you were going to be able to conduct your work with a crew size of 10 and get the work done in 6 months, you found out that suddenly you were only going to be allowed a crew size of 4, and the work was going to have to be done over a period of 8 or 10 months, and consequently, the efficiency with which the work was going to be done was going to be very much changed. And in many cases, in order to try and continue to hold the original project completion deadlines, there were huge changes made in scheduling that resulted in the inability to progress the work and to perform the work in the efficiencies that had been anticipated at bid. We saw that a lot, and we spent a lot of time reserving our rights with regard to that. So once we've identified these, once we've reserved our rights, what is it that we have to do in order to prove our entitlement to recover anything, whether it be time or whether it be money? This is a chart that shows as planned versus as built, which shows the difference. The accelerate in this case, there was an original completion date that was supposed to be out there on October 1st, 1999. This is an old chart, obviously, and it shows that the work actually went on until the end of February, and consequently, the as-planned hours that are shown in the red were exceeded. And as you can see here, we've got a chart that provides the additional regular time hours that the delay caused, and then the additional overtime hours that the delay caused. And this is a graphic demonstration that might be used in a schedule analysis to demonstrate the severity of the problem. This is a project that the accelerated actual completion date was then forecast to be New Year's Eve 2099, but that obviously didn't happen. So when we seek to prove our entitlement in quantum, we're going to have to show and prove the conditions that have changed. And in most cases, we're talking about schedule, durations, and in some cases, if we've had a delay and it's pushed the work into a time of year that we didn't anticipate, certainly site development work that was scheduled for the dry summer months, if in fact it's been pushed off to the winter, got a real problem, especially in the Puget Sound area. Those are the kinds of things that we have to demonstrate both narratively and graphically. And then we have to talk about how those conditions resulted in less than the anticipated labor efficiency. And overarching from all of these, and I think this is on the following slide, one of the things we have to demonstrate was that the assumptions we made about the efficiencies we would achieve were valid at the time of the bid. And that becomes an interesting and challenging sometime amount of proof. But if we had a reasonable bid, if in other words, the surrounding pricing, the pricing from others that competed with us for that work, and we were not far apart, that generally shows the validity of the low bidder's price, and then consequently the assumed efficiencies, crew sizes, and those kinds of things. And then we have to talk about, lastly, why the impacts that we're claiming. And this works for any delay, any inefficiency issue, whether it's caused by the pandemic or not. We have to show why we were unable to anticipate those and account for those at the time of the bid. So here I've cut and pasted into this slide the MCAA factors. These are factors that the Mechanical Contractors Association of America has developed and have been extraordinarily helpful to my clients in trying to evaluate, and I mean not only my mechanical contractor clients, but general contractor clients and those of other trades, to at least outline the kinds of inefficiencies that are visited on contractors when a project has been delayed, when there's been a suspension, when the work's been halted and then restarted again in some way. And it goes through a number of these. These descriptions are very helpful to understand what's really going on in a situation in which the work has started and the schedule has slipped. And in many cases, sometimes the duration that was anticipated when the work has restarted has somehow been shrunk, or we're trying to hold the date. And so the activities that had been strung out along the schedule have now become closer together and become stacked. And so lots of these factors enter into it. If you have to have an increased crew size to perform the same amount of work in a shorter time, they're going to be by definition less efficient. If they have to work around other trades that otherwise would not have been there under the original schedule assumptions, then we got a problem. Crowding, sometimes stacking of trades. Concurrent operations is another aspect of that that's covered in these. And then again, when you've got supervision that was designed to, let's say, supervise a crew of 10 and now has to supervise a crew of 25, again, that becomes a problem because supervision has been diluted in that case and it is less efficient than it would have been trying to line out the crews for the day. When you add new people to the crew, there's a learning curve aspect of that, and that's covered in these productivity tables. If you work too much overtime, it becomes a fatigue problem. All those kinds of things enter into it. So the ability to prove entitlement requires some description of why. what the actual cause was, what the resulting cause of what the result was caused by the delay. In other words, we were delayed and now we've gone back to work. We've been given less time to achieve what it was we were going to do. And these are the results. We're having all these issues which have led us to be less efficient. These are an excellent guide. Now, there are other ones out there. There are numbers of other studies on these inefficiency issues. And there are experts in this field that can assist. And most lawyers are well familiar with this kind of stuff. So just so you have an idea of the kind of factors that go into these efficiency claims. So as we continue in proving entitlement, we have to prove the differences between our assumptions and what actually occurred. So this is what we call the as planned versus as built. One of the way we do this, if we can, is in that top graphic that I've got there is called the measured mile. If there is a quantity of work that can be seen in a before and after impacted status, this is how efficient we were working this. After the impact, this is how efficient we were able to do. It's the same work, and consequently, the impact is the difference between what we had been able to achieve and all we're able to achieve now. And the measured mile is a very persuasive tool if it's available. I've had where there have been repetitive work tasks, I have been able to get very good results, including negotiating with public owners when I've been able to demonstrate the existence of a measured mile. We have to prove the efficacy of our original estimate. Got to show we didn't blow the original estimate and it just wasn't a bad estimate. And then if we've got actual records, just like we do sometimes with change orders, if we can assign a code and start tracking the things, especially with regard to COVID, that are additional, that are new tasks, and that includes the pre-site screening that has to be done for which we have to pay our people. Those kinds of things, if we can track those so that we have actual records of them, that becomes very persuasive evidence. So the actual increased costs, if something has changed, and I have had a number of these recently, in which projects got delayed, and during that time, personnel, their compensation changed. If they were union contractors, in many cases, it went into a new collective bargaining period, and the compensation of all the workers changed. And it would work the same in a merit shop, whether or not we were dealing with it. If what happened is the amount we anticipated we would have to pay for labor increased because the delay period pushed us into that increased period, then those are legitimate claims to make, but we have to prove them. So now looking forward, what are we seeing? So what happened after March when new projects started to come online? Well, looking back at projects that were existing, I saw a number of terminations for convenience in which project owners terminated their contractors, hoping that they would be able to deal with the losses that they were dealt from the pandemic by trying to re-procure the work at hopefully better pricing. I saw this in particular with a mid-rise building in Seattle, where my client was terminated specifically for convenience, specifically because the owner thought that it could get a better deal elsewhere. In that case, my client was happy for a termination for convenience and was paid all its costs and went on its merry way. But those are the kinds of things that I saw a number of times in which owners said, okay, we're coming back out of the pandemic. This is a good stopping point with you, so we're going to let you go, pay your costs and your reasonable profit through the current date, and we're going to go on and see if we can find a way to get some of our money back by trying to shop this job around town. I began to see new contracts with force majeure clauses that specifically excluded pandemic, epidemic, or public health crises. And in one case, it came from a very well-known local company that was issuing a master agreement to my client, and we crossed it out. They had added it to a standard agreement after the pandemic started, and we said, yeah, that it can't really do that now that we're in it and you want to buy our services. This is not a risk we're willing to take. We don't anticipate that we'll not be able to understand and price our forward-looking work with the pandemic in mind. But what we don't know is what we don't know, and consequently, we can't have pandemic to be a force majeure clause that would excuse the owner from any compensation were additional impacts not anticipated in our bid be imposed on the project. I saw lots of attempts to realign schedules to lessen the impact and to hold completion dates. Many owners are really in a box because they've made promises to third parties for the delivery and the availability of projects, and if they don't have them, there were real problems. And so there were a lot of negotiations and bargaining back and forth and a lot of reservation of rights letters while everybody tried, in most cases very cooperatively, to come up with a brilliant solution of how we might be able to not impact the completion date, not cost the owner every single nickel in the entire world, and still give the contractors the ability to realize the fees to which they should have been entitled based on the efficiencies that were anticipated at bid time. Lots of creative thinking. There's a lot of smart people in this industry, and a lot of things were able to happen with agreements that were surprisingly cooperative and seemed to be working out well. I also saw in some cases just the absolute, here, this is how we're going to do it, and no recognition that this is how we're going to do it was different than the promise you made me when we signed this contract. And I saw a number of instances where I think it was let's run this up the flagpole and see if anybody pays any attention to it. And in most cases, smart contractors will pay attention to the fact that they're being asked to do something extra for free, and that was the case. And so in a number of cases, that was the first step, and then the cooperative efforts I talked about earlier were the next step, and that's where we found ourselves. So now, preserving our entitlement, looking for today, here we are in 2021, what do we do? And how do we deal with the risks that come with the pandemic, both for the projects we're on and any impacts that we continue to suffer, and for those projects that are entering the pipeline today and that we're looking forward to, understanding that with hope and the promises we're getting from the new administration that we're all likely to be able to be vaccinated as soon as by the end of summer. And maybe we're dealing with an issue of herd immunity, and maybe we're back to some sense of normality inside of this calendar year. All of that would be great. But the problem is everybody needs to hedge their bet a little bit because nobody knows. Nobody could have anticipated at Christmas time 2019 what was going to happen in 2020 and what has continued to fall out even as we've emerged a little bit and as we've got smarter and as we've been able to learn to work more efficiently in the ways we have in 2020 and 2021. Let's remember that the pandemic's nobody's fault, but it's especially not our fault. We didn't have anything to do with it. We're just the contractor here. Exercising and preserving our rights under the contract is not an adversarial issue. It's simply business. When the contract says either provide us notice or waive your claim, it's only business to provide the notice. You can always withdraw it. You can always say, hey, as it turns out, we're good. We don't need that, and we're withdrawing, and we don't need a change order for that anymore. But if you don't do it, you'll never get a change order. So there are other creative solutions, and if it doesn't visit some disadvantage on you, explore them. It doesn't hurt you to have good relationships with people and to work cooperatively with them to everybody's benefit. If you're confused what to do, submitting a notice letter is simply protection. And I've used this line. Many of you have seen me speak at ABC before. I've been doing it for a long time now. I say this: thin armor is better than none at all. Writing a letter that reserves your rights and saying, out of an abundance of caution and not understanding how this is all going to shake out, in compliance with this section of our contract, we're providing notice of the potential impact resulting from whatever the issue is. And then we've put ourselves in a position where we've got a defendable argument that we reserved our rights, and then we can figure out what to do next, including whether or not we're able to quantify it, whether or not we need to write a letter saying we can't yet quantify it, whether we need to say, sorry, our bad, it's not an issue anymore. So we need to, as we move forward, we need to carefully analyze the changes that are made in schedules. If we have a contract that includes a schedule as a contract document, updates need to be carefully reviewed for differences between what we had anticipated was going to happen and what now we're told is going to happen. We have to pay strict attention to the order and the duration of our activities, including the work that's precedential to ours, in order to make sure that we understand whether or not we're going to be able to achieve the efficiencies that we had hoped, whether we're going to be able to achieve the work in the time allowed with the crew size we anticipated, which would then tell us that we're going to be as efficient as we'd hoped to be. So with that, we're going to close this, but I want to thank you for paying attention. You're welcome to contact me at any time. If you look below in the comments, this presentation will be linked, and you'll be able to use the hyperlinks to those studies that were done by those 4 industry groups. Thank you. Stay safe.